Note that for everyone present for the Zoom meeting, like a regular in-person meeting of the board, it's being recorded and will be archived on the State Bar's website. So I would like for Lisa to call roll at this time.
Chun?
Here.
Cisneros?
Here.
De La Cruz?
Here.
Duran?
Here.
Iglesias?
Here.
LeBron?
Yes, here.
Manning?
Here.
Pertula?
Here.
Slade?
Here.
Stalling?
Here.
Steinbrecher?
Here. All right, so just to give everybody a roadmap, the committee will take items on the agenda in the order in which they appear, with the exception of the closed session. After all open business items are completed, the committee will go into closed session to take item business 2A, which is the rule of procedure 2201 case status updates. We will be taking public comments today. For those of you who are participating via Zoom, you should have a function for virtually raising your hand. If you wish to make a public comment, please use that raise hand function. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key with the number 9. Doing so will alert us that you would like to make a comment. And bar staff will apprise the committee if there are any virtual hands that appear. We would ask you to limit your comments to 3 minutes. You will be notified when you have 30 seconds left to conclude your comments. At 3 minutes, we will turn off your microphone and call the next member of the public. So at this time, are there any individuals either on Zoom or telephone that would like to make public comment before the Regulation and Discipline Committee?
Okay, I don't see any hands raised in the attendee list.
We'll move on to the chair's report then. I'm happy to report that your vice chair and I, Ruben Duran, we have been busy meeting with State Bar Court on some of the initiatives that have come out of this COVID-19 crisis. You'll note that item C was withdrawn, and that is so we can further collaborate with State Bar Court and Defense Counsel to craft rules that efficiently, or allow us to efficiently handle the State Bar Court business, especially in today's time and changing issues. So with that, we'll go on to consent agenda. We have no items on the consent agenda, and so we'll now turn to items for discussion, beginning with item business 3 sub A, which is a formal advisory ethics opinion. And Andrew Tuft, I believe, is on the line, is going to be apprising us of this agenda item. Andrew, are you there?
I am. Excuse me, I am. Good afternoon, everybody. Are you able to hear me?
Yes.
Yes.
Okay, great. So yes, my name is Andrew Tuft. I'm the supervising attorney in the State Bar of California's Office of Professional Competence. And in this role, I act as staff counsel to the State Bar Standing Committee on Professional Responsibility and Conduct. This item requests RAD approval for publication of the attached ethics opinion, which analyzes a California attorney's ethical obligations when providing legal advice to a cannabis business in California. Publishing ethics opinions is regular and routine work of the committee, and as a result, you may have noticed over several RAD committee meetings that typically a request for approval to publish an opinion is generally placed on RAD's consent agenda. This opinion, however, addresses an issue that has been a topic of interest within the ethics community and frankly all practicing lawyers for several years, and specifically that is what advice and assistance may be provided to a client when the client's conduct is lawful under state law but might violate federal law. Several jurisdictions have addressed this topic. I don't want to give any false premise that we're breaking new ground here. Our conclusion is in line with much of those other jurisdictions. However, within California specifically, guidance on this issue was most recently provided in November 2018 when the revised rules of professional conduct were made operative by the Supreme Court of California. And specifically, comment 6 to Rule 1.2.1 states in part that a lawyer, quote, may assist a client in drafting or administering or interpreting or complying with California laws, including statutes, regulations, orders, and other state or local provisions, even if the client's actions might violate conflicting federal or tribal law. If California law conflicts with federal or tribal law, the lawyer must inform the client about related federal or tribal law and policy, and under certain circumstances, may also be required to provide legal advice to the client regarding the conflict. And this opinion analyzes that provision in the context of advising a cannabis business. And the opinion also addresses additional ethical considerations an attorney should be aware of in such a situation, including, for example, the duty of competence, confidentiality and privilege, and conflict of interest. And with that, the committee respectfully requests RAD's approval to publish the opinion on the State Bar's website. And I'm also happy to answer any questions to the best of my ability if you have any.
All right, are there any questions for Mr. Tuft?
Alan Steinbrecher, I make the motion to approve.
All right. Is there a second?
This is Jose, I'll second.
All right, so first by Alan, second by Jose. Lisa, can you please call the roll?
Chen? Chen? Sorry, is she muted? Okay.
Yeah, it looks like she's muted.
Yeah, she is muted.
Oh, sorry. Yes, I was having trouble unmuting.
Okay, terrific. Chen?
Yes.
Cisneros?
Aye.
Del Cruz?
Yes.
Duran?
Yes.
Iglesias?
Yes. Yes.
LeBron?
Yes.
Manning?
Yes.
Petula?
Yes.
Leg?
Yes.
Stalling?
Yes.
Steinbrecher?
Yes.
All right, the item passes. Excellent work, Andrew. And it looks like you have item B, which is the Western San Bernardino County Bar Association's proposed mandatory fee arbitration rules of procedure and a request for approval. So Andrew, please tell us what this is about.
Absolutely, thank you. So switching gears, also in the Office of Professional Competence, I help to supervise the mandatory fee arbitration program. And this item requests RAD's approval of the Western San Bernardino County Bar Association's proposed rules of procedure for fee arbitrations to be conducted by their program. Business and Professions Code Section 6200 at SEC provides for non-binding fee arbitration of disputes concerning fees, costs, or both charged by attorneys. And under 6200D, arbitration of attorney fee and cost disputes may proceed under a arbitration program sponsored by a local bar association, so long as the local rules are approved by the board or a committee designated by the board. And RAD is a committee designated by the board to approve local county rules and procedures. And the Western San Bernardino County Bar Association submitted their proposed rules to the State Bar's mandatory fee arbitration program, requesting review and approval so that they may establish a local program to conduct themselves. Their proposed rules have been reviewed by the mandatory fee arbitration program staff, as well as the State Bar's presiding arbitrator, all of whom have found these proposed rules to be in compliance with Business and Professions Code Section 6200 at SEC, as well as the minimum standards and guidelines for the operation of mandatory fee arbitration programs. And as a result, it's recommended that RAD approve the Western San Bernardino County Bar Association Rules of Procedure for Fee Arbitrations as attached to the agenda item, and following the approval that will authorize the Western San Bernardino County Bar Association to establish jurisdiction to hear fee disputes arising in their county.
All right, are there
Randy,
any
this is Sean.
questions?
I'll move the item.
All right, Sean moves it. Is there a second?
Alan Steinbrecher, second.
All right, and then a second by Alan. Lisa, could you please call the roll?
Sure. Chen? Chen?
Yes.
Okay, Chen.
Yes.
Yes. Okay, Cisneros?
Aye.
De La Cruz?
Yes.
Duran?
Yes.
Iglesias?
Yes.
LeBron?
Yes.
Manning?
Yes.
Pertula?
Yes.
Selig?
Yes.
Stalling?
Yes.
Steinbrecher?
Yes.
All right, item passes. Thank you so much, Andrew, for your work on this.
Thank you.
All right, I would just note again that item 3C has been withdrawn, and part of the purpose is to continue to collaborate with State Bar Court on some of these items, and I anticipate that we will have this agenda item hopefully to this committee by July. So we'll, Ruben Duran and I will work with State Bar Court and Defense Bar to continue to craft these rules. Going on to item D, which is request for approval of rule changes to permit video conference appearances and electronic service of process and fee arbitration procedures. And James Chang is the presenter. So James, can you please present this to the committee?
Yes, thank you, Brandon, and good afternoon, committee members. This item is a proposal for a package of rule changes that would collectively authorize both electronic service of process as well as video conference remote appearances in fee arbitration proceedings conducted both by the State Bar as well as by local bar associations. The committee may recall that at the April 16th board meeting, the board approved an emergency measure to allow electronic service of process and fee arbitration proceedings immediately for proceedings that are conducted by the State Bar. This proposal would circulate that rule for public comment as a proposal for permanent adoption as a change to the rules. And it would also approve of any similar rule changes that are enacted by local bar associations. As Andrew Tuft mentioned in the previous item, rules of procedure, the rules of procedure of local bar associations for fee arbitration proceedings must be approved by this committee, the Regulation and Discipline Committee. And so this item would propose that the committee deem approved any similar rule changes that are enacted by local bar associations. So collectively, this series of measures would allow electronic service of process in all fee arbitration proceedings, both those conducted by the State Bar as well as by local bar associations. Similarly, for video conference appearances, under the current rules, there is a provision that allows for telephonic appearances with the approval of the arbitrator in fee arbitration proceedings. This rule was written about 15 years ago when it was not contemplated that there would be the availability of video conference. Many of the arbitrators have requested guidance as to whether the current rules that allow appearance by telephone could be interpreted to allow remote appearance by video conference as well. And we thought that the best approach here would be to explicitly clarify in the rule that video conference is an approved form of remote appearance. And so, again, this is a package of changes. It would first amend State Bar rules to allow video conference appearances in fee arbitration proceedings conducted by the State Bar effective immediately. It would also circulate this rule as a proposal for permanent adoption, and it would also deem approved any similar rules that are enacted by local bar associations, so that local bar associations will not have to return to the State Bar to request approval when they enact similar rules. So that is the proposal and the mechanics of how it would work. Happy to answer any questions that the committee may have.
All right, are there any questions for James? All right. I would entertain a motion then to approve this item.
So move. This is Duran.
All right, first by Ruben Duran. Is there a second?
This is Hyland, second.
Second by Hylin Chen. Lisa, can you please call the roll?
Chen?
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning. Manning, is she muted? Is Manning muted? I can.
Right here now.
Okay, Manning,
Yes.
Pertula,
Yes.
Deleg,
Yes.
Stallings,
Yes.
Steinbrecher.
Yes.
All right, item passes. Thank you, James. All right, we'll move on to item E, review of the metrics under the purview of the RAD Committee and Discipline System Statistical Report. And Lisa, please take us away on this.
Hi, good afternoon, everyone. My name is Lisa Chavez, and I'm the director of ORIA, the Office of Research and Institutional Accountability. And let me go ahead and pull up my PowerPoint presentation. Oops. Share screen. There we go. So the purpose of this presentation is to focus on the discipline metrics that are under RAD's purview that were reported out in the Q1 2020 metrics report that is going to be attached to Donna's executive director report, and also to describe the contents of the discipline system statistical report, the DSSR, that is attached to this RAD agenda item. So the first thing I'm going to do is talk about these two different reports and how they speak to each other and how they complement each other. I'm doing that because we have a few new board members and we did not issue a DSSR in March. And so the last time we did that was in January. So it would be kind of a good refresher for everyone. And then next I'll close with, among all the metrics that we report out on, in the metrics report, I'll focus on those under RAD's purview that did not meet their accountability targets. And the offices in particular that are under RAD's purview are the Client Security Fund Lawyer Assistance Program, OCTC, Office of Professional Competence Probation, and the State Bar Court. So let's first talk about the metrics report. Again, this is a report that is going to be attached to Donna's executive director's agenda item report. And this particular report that we're issuing reports out on all State Bar metrics that for the Q1 2020. And in particular, we're reporting out on 66 metrics that are reported at the monthly level or at the quarterly level. These are metrics across most of State Bar operations. Among these 66 metrics, 56 have targets for accountability purposes. So that means that 56 metrics have a target that an office is trying to meet for the purposes of accountability. And what we do is for each of those metrics, we compare their Q1 result with that target. And we do an evaluation whether they met that target or not. So in the case of those 56 metrics, 12 did not meet their targets. Out of the 66 metrics that we report on in that report, 39 are under RAD's purview, under the offices I just described. And just for your information, in this particular report, even though the majority of the metrics we're reporting out on are for Q1 2020, for the metrics that are under RAD's purview, we also report out on data for Q4 2019 because we didn't report that out in March because we needed to ensure that the data that we report out was aligned with that we had to report for the ADR. So you also received, as part of an attachment to this agenda item, what we call the Discipline System Statistical Report. And how is this report different than the metrics report? It's different in a few key ways. The first is that, like I described with the metrics report, the purpose is to describe the most recent quarter and compare it to a target. And whereas this report, wherever we report out on a metric, we provide 13 months of data. We also, in this report, give non-metric data that gives the reader a little bit more context to the metrics. And then we also include some additional analyses. For example, we analyze outcomes among people who have received a disposition. We also report out on complaining witness surveys. Okay, so let me give you an example of how a topic can be reported in the metrics report versus in the DSSR. So the left, here's an example of us reporting out on a metric for OCTC, and this is their annual caseload clearance rate. As you can see, we reported out for late December, and then the first 3 months of this year for the Q1. And the bars, throughout the metrics report, if a metric did not meet its target, that value is shown in red. And if it did meet its target, it's shown in green. And on the far left, that's the target that the metric is trying to meet. On the far right, this is what you see in the DSSR. It shows 13 months of data, so that you're able to see how this particular metric has performed over time for the previous 13 months. And as you can see on the right, there's no color coding. It's just because we're just reporting out on data. So let me give you another example. In the DSSR, we do an analysis of the overall OCTC inventory, and we show it by different stages. So again, this is just for your information to give a little bit more context to the metrics. So what this chart shows, and this is just one of several charts that are not metric, that are not based on metrics. These are just, you know, interesting pieces of information for you to learn more about our different offices. This shows the different OCT inventory by different stages. So you see the total inventory on the left. These are the total, and this is reported out by month. You know, the number of cases that were for intake, investigation at the pre-filing stage, and the post-filing stage. Okay, so now I'm going to turn to metrics that did not meet their targets. So as I noted in my introduction, 39 discipline system metrics were reported in that metrics report. 29 of them have targets for accountability purposes, and 6 did not meet those targets. And I just want to let you know that the agenda item that I wrote up was inaccurate. I reported out on 3, but in reality, 6 did not meet their targets. Okay, so the first one that did not meet its target is the lawyer assistance program. As you can see, we reported out on several quarters worth of data, and they only didn't meet one quarter for a metric that has to do with responding to 100% of requests for presentations within 2 business days. So what we learned was that they received in Q4 2019, they received 21 requests for presentations, and they responded to all but 1 within 2 days. Sorry, let me just pause there. What we do is whenever an office does not meet their target, we ask them to provide an explanation for why they did not meet their target, and if applicable, what their office is doing moving forward to meet that target. Another metric that did not meet its target was one under OPC. They have a metric that examines how participants of an e-learning course reported out. It's like a survey that they give it at the end of the course, whether or not that course met their expectations. And the target is that 85% of participants are going to report that the course met their expectations. And as you can see for Q1 2020, only 75% of participants said that it met their expectations. So the course subject for this metric is the California Rules of Professional Conduct. Staff believe that one reason why this metric was not met is that first, the content is very sophisticated and they're very robust, and survey respondents also kind of viewed the 2-hour seat time negatively. And so staff shares that they will continue to analyze survey respondents to learn more about what changes may be made to improve participants' experiences. Another metric that did not meet its target is an OCT metric on the annual caseload clearance rate. Now, this metric is calculated using a 12-month rolling average of monthly caseload clearance rates. And as you can see, did not meet the 1.0 target in the months of December and January. And that's largely due to the fact that though, because that's calculated at the 12-month, that was still considering February 2019, which had the lowest monthly caseload clearance rate of the year, because that was the year that was the month that Odyssey went live. And so as you can see, starting in February and March, that month of February 2019 is no longer part of the calculation. And now they're meeting the target. All right, State Bar Court also has an annual caseload clearance rate of 1.0. And as you can see, out of the 4 months that we analyzed, they met the target in 2 out of the 4 months. What's interesting is that the State Bar Court has consistently met this target up until recently. So State Bar Court staff reviewed the cases that resulted in this metric not being met in February and March, and they concluded that case processing delays were caused by factors outside of their control, outside of the State Bar Court's control. And then finally, 2 more metrics within State Bar Court did not meet their targets within 3 months of the 4 months analyzed for each of them. It has to do with hearing departments reaching final outcome within their timeline requirements. And again, staff reviewed the cases that prevented them from meeting this target and concluded that these delays were outside of the State Bar Court's control. Okay, do you have any questions about the metrics?
Anybody have any questions for Lisa? Lisa, I have one, and maybe this could be also posed to Melanie or Steve.
Okay.
But in regards to the State Bar Court, the clearance rates there, did the State Bar Court articulate the factors that were outside of their control that they believe led to not being able to meet these metrics?
We talked about this. The thing is they gave me some examples, but I think they applied to the hearing department. I think that it has. I've talked about it.
I'm not sure if she's prepared to respond to this question, but I see that Erica Doherty is one of the attendees, and Erica may be in a position to respond. She wasn't prepped for this, so she may not be, but if we can promote her and see if she's able to respond.
Donna, can you hear me?
Yes.
Oh, good. Okay.
Yes.
I wasn't sure. I'm viewing from a computer that doesn't have a video, so I wasn't sure if you'd be able to actually hear me. So my understanding is that this is caused by cases in which they're consolidated proceedings, as an example, and there may be other reasons, but that's one that I'm aware of, meaning that in some instances, there was an older case that became associated with a newer case. And so that can impact that metric. But again, that's my limited understanding. And there are people in my office that have much more knowledge of this than I do.
And so thank you, Erica. And I'll add Brandon, because I asked that very same question when I saw the description. And I asked Lisa to get some more information. And so among the other pieces of information that were reported is that the State Bar Court obviously does not have power to sort of force people to file documents when at a given time, or cases may be continued. There are sort of a variety of issues that the litigants control that the court itself can't control, that impact the ability of it to ultimately dispose of a case. And so those are the types of things that the court is referring to when it's saying that's out of the control of the court. That sort of stands in the way of the court being able to clear the case just by its own scheduling and calendaring. People request continuances and things like that.
All right, thank you both for your response on that. And then Melanie or Steve, did you want to comment on any of the items relating to OCTC? Any other information you think this committee needs to know?
I don't have anything. I think Lisa did a fine job of explaining our caseload clearance rate.
This one right here.
All right, any other questions or comments from the RAD committee members? Okay, seeing none, this does not require approval as a report. So we will move on now to item F, which is the Office of Professional Competence update by Randy DeFontorum. And one of the things that was discussed by the vice chair and myself in preparation for this meeting is really the importance of the Office of Professional Competence and what it means to each individual lawyer in California. This is one of the most important functions, I believe, that the State Bar is able to perform, which is provide training and oversight of attorneys' mandatory continuing legal education requirements, and in so doing, hopefully prevent harm to members of the public who hire lawyers. And so this is an incredibly important topic. And so Randy, I appreciate you letting this committee know what your office has been up to and different resources that are available for lawyers who might be on the line who wish to further their continuing legal education. So Randy, go ahead.
Thank you for that introduction, Brandon. The Office of Professional Competence, OPC for short, administers the State Bar's attorney professional responsibility programs, resources, and committees. My presentation will focus only on some of these activities, but I have provided a comprehensive overview in the agenda materials. Broadly stated, OPC's goal is to set and maintain high standards of professional conduct. OPC's programs are intended to protect clients by promoting a lawyer's awareness of and compliance with their professional responsibility obligations. Probably the most well-known program of the Office of Professional Competence is the Ethics Hotline. The Ethics Hotline is a telephone research assistance for questions concerning attorney professional responsibility. The Ethics Hotline does not give advice or render opinions, and we actually give a disclaimer on every call to that effect. But the hotline does help a lawyer discuss issues and gives them a great head start in researching a legal ethics question. Originally, the hotline was staffed by law clerks and later by paralegals. Presently, the hotline is staffed by 4 senior program analysts, all of whom are supervised by an attorney. And in fact, 3 of them presently hold a JD degree. The second bullet you see on the screen is a quote from the California Supreme Court case where the court ordered an assessment to continue the public protection function of the bar after the bar's fee bill was vetoed. In reasoning that the ethics hotline was a key public protection function, the court said that the ethics hotline saves cost to the discipline system. Now, they didn't give a number for what that cost savings might be, but just recently I had the privilege of giving an annual service award to an ethics hotline staff person who had reached his 30th year of service to the bar. And he's actually retiring this year, so we're sad to lose him. We'll need to replace him. But that got me thinking about what is really one way of looking at the monetary savings to the discipline system of the ethics hotline. And so in 30 years of service, my staff person in a 250, say, workday a year might have assisted anywhere from 16 to attorneys each day. So that amounts to about 4,000 attorneys a year. For 30 years of career ethics hotline service, that's 120,000 attorneys. Now, let's say if the hotline wasn't around, if he wasn't there for those 30 years assisting those attorneys, maybe 5%, 120 of them would have ended up in the discipline system. That would be about 6,000 attorneys. And RAD knows, of course, that the bar can recoup discipline costs and cost certificates if a respondent goes through the hearing department and the review department. You know, those can be, upwards of $20,000. But I understand that many of those settle. So I'm informed that an average cost certificate is more like $4,000 to $5,000. So if I use the conservative $4,000 figure, what we have is 6,000 attorneys times $4,000, and that 30-year service of ethics hotline staff person yields a grand total of $24 million. And so when I see that quote, and I use it often, about how the ethics hotline saves the discipline system, until you really put a number on it, 24 million, it doesn't really sink in or resonate. The next screen is the primary issues. And so these are the categories of questions that attorneys present to the ethics hotline. And the ones you see on screen are probably the most common ones year in and year out. They don't change much. In fact, I went back to the stats from 2005, and the top three, two of them were exactly the same. Although they don't really vary too much in terms of these primary issues presented to the hotline, I am watching them closely now, largely because if you look at the top three, communications with clients, adverse party, fees and costs for legal services, conflicts of interest, in the new rules of professional conduct, the rules that became operative in November 2018, we've made some major changes in those areas. And so, for example, in the conflicts area, we no longer have unique California conflicts rules. We have rules that largely track the ABA model rules of professional conduct. In the area of fees, one of the questions that the hotline used to always get was, am I required to place an advance payment for fees into my client trust account? If you go back to the Baranowski case from 1979, that created some question marks as to whether or not funds paid as fees in advance, whether that really constituted funds held for the benefit of the client under the language of the then client trust accounting rule. And since that time, lawyers had the discretion whether to put an advance fee into the client trust account. But that has changed. In the new rules, you are required to place an advance fee into the client trust account, subject to some exceptions. And then the number one category, communications with clients, adverse party, there was a major change there as well. The former rule on communication with a party represented by counsel, quote unquote, used the operative term party. When many other jurisdictions had changed, that was the old model code word, communication with the party, to what is in the model rules, communication with the represented person. And that is now changed in the California rules. And so I'll be watching in the future to see if these top three categories, if there is any difference in terms of the frequency that we get questions in those areas because of the changes in the new rules. The next screen is the ethics hotline call volume. And so this is, I guess you could say, your classic good news and bad news. The bad news is that the call volume will most likely be down this year. The 2020 year-end projection looks like about 3,500 less calls than what we have for the call volume for 2019. Now, I guess this should be no surprise, since 2020 will likely be one of the most atypical years in California history for everyone, not just the legal profession. The good news, however, is that although the total volume is down this year, completed call percentage is high, probably the highest it's been in many years. In 2019, about 80% of all calls were completed, but for 2020, we are projecting a completed call percentage of over 90%. And that's great, because if we will inevitably be having a lower total call volume, then at least a much greater percentage of them are getting their calls handled right away. Now, this completed call percentage number can be misleading, because it doesn't mean that the balance, either in 2019, the 20%, or the projected 2020, 10%, doesn't mean they get no help at all. Somehow their calls were dropped or lost. It just means that sometimes there's a telephone tag that means that the calls were not completed right away. And sometimes we ultimately do catch up with them. Now, we had sought to fix that last May when we transitioned to the Cisco inbound call center, much like the Archer call center. And we had just sort of got in our groove with that new way of taking calls, so that we don't have to keep a queue and call people back. They would just be distributed to any available staff person as they came in. but we've had to revert back to the old system in this current telecommute staffing environment. But I must say, it's working well. I saw the stats from yesterday. We had total 45 calls in, and all 45 calls were handled that same day. So I think it's working. The next screen, although I do want to get back to that Cisco inbound call center when we get back to the office, is the performance metrics. And Lisa just gave you some information about one of the OPC metrics, the e-learning. This one is for the ethics hotline, and it asks that the user's feedback be tracked. And what we're shooting for as our benchmark is that 75% of the callers report a high level of overall satisfaction with a 4 or above rating, with a scale of 1 to 5, and 5 being the highest. And happy to report that for the first quarter of 2020, 100% of the feedback was that rating, 4 or higher. In the next screen, you'll see that the feedback we get isn't just simple ratings. In addition to a post-call automated survey when we're using the Cisco system, we also have used for many years an online form for hotline users to provide feedback, ratings, as well as an open field for comments. And this screen right now has a very representative comment from one of our users from April 6th. And we also take a voluntary demographic survey. So we ask lawyers how long they've been in practice, and how big is their firm. And we found over the years that the largest segment of our users tend to be smaller solo practitioners, which is not surprising because those are the practitioners who don't have the safety net of any sort of internal risk management committee or a partner who is a resident legal ethics expert. Instead, these solos or small firm practitioners are trying to put all their energies into serving their clients well. And the ethics hotline is the perfect support for them for an area of law that they don't encounter often, but is just as deep and tricky as any other area of law. The ethics hotline is there to make sure that they serve their clients in a professionally responsible manner. Fortunately, the criticism we get oftentimes in the same comment suggestion box is that they wish the ethics hotline would give advice. Of course, we can't do that. The questions are, they're submitted to us ex parte. The information they provide is very limited. Oftentimes they portray the facts in sort of best light. So it really wouldn't be responsible for us to give what they're asking. And what they usually ask for is, I won't hold you to it. Just give me your opinion. You seem to know these rules like the back of your hand. Just tell me what you would do. But we can't. But where the hotline can't give an opinion, that's where COPRAC comes in. The Standing Committee on Professional Responsibility and Conduct is there to take hypothetical questions. Usually the questions they choose to opine on are ones affecting a lot of lawyers. And they actually give you an analysis opinion. They apply the rules to the hypothetical facts, and they tell you what is ethical, what is not ethical. Something the hotline can't do is what exactly COPRAC is doing. And you heard from Andrew earlier about the ethics opinion on advising a cannabis business. We now have an ethics opinion that we can give to those callers. They won't have to push us to apply the new rule 1.2 and how that comment works. They have the ethics opinion. And on screen, you can see some of the other recently published ethics opinions and some draft opinions that are circulating for public comment. One of them there concerns data breaches, which in this time period where lawyers are practicing probably exclusively by technology is probably a timely opinion to get out there. The opinions are non-binding, and like the ethics hotline, they include a disclaimer at the end of every opinion saying that they're not binding. But over the years, they have been cited by the State Bar Court, the Court of Appeal, and even the California Supreme Court on issues of attorney professional responsibility. The next slide. Are some of the other programs, and I apologize for rushing, but I want to give a lot of time for questions and answers. I don't want to take up the time speaking, but the mandatory fee arbitration program is one of the programs that is new to the Office of Professional Competence. And I should mention that with regard to COPRAC, the 12 volunteers on COPRAC now include 2 members with fee arbitration experience, also a public member, but the 2 members with fee arbitration experience are on COPRAC now because of the sunset of the Mandatory Fee Arbitration Committee. The Mandatory Fee Arbitration Committee was responsible for issuing the arbitrator advisories, and that has now been assumed by COPRAC. And so we are, as part of our recruitment and appointment process for COPRAC, always on the lookout for persons who have the fee arbitration experience, because COPRAC will be issuing, going forward, the arbitration advisories. The mandatory fee arbitration program, what I was saying earlier about the Supreme Court's observation about the hotline and how it supports the discipline system by keeping things from clogging up the discipline system, that same comment can be made for the mandatory fee arbitration program. If the mandatory fee arbitration program was not there to provide a fair and efficient forum for resolving fee disputes, many of those complaints would end up in the discipline system. And that would be despite the fact that our rule on fees prohibits unconscionable fees as opposed to fees that are just unreasonable or too high. But fortunately, we do have a mandatory fee arbitration program, and that does funnel things that are pure fee disputes, no misconduct issues, into a proper forum for them to be resolved. The staff of the mandatory fee arbitration program conduct their own state bar fee arbitration proceedings when a local bar is not able to. There's about 30 local bar programs. If like a fee dispute arises in a county where there isn't one, then the state bar will handle it. And annual average, as you can see, is about 63 cases every year. And then if lawyers don't comply with their arbitration orders, if they agree to make it binding, for example, then the bar staff will engage in enforcement actions. We have an annual average of about 27 cases in that regard. The second bullet on the screen is for the lawyer referral service program. OPC inherited mandatory fee arbitration last year, and this year we are taking on the lawyer referral services program. And the lawyer referral service program provides oversight for local bar and other referral programs to assure that they lawfully operate. These programs must be certified by the state bar and must comply with the minimum standards adopted by the board. These standards include, among other things, that the panel attorneys possess malpractice insurance, and that the referral panel actually has a criteria and procedures for assuring that the panel members to which clients are referred actually possess the requisite expertise for receiving those referrals. It's a very important program. And we even are now looking at the issues of complaints concerning uncertified referral activity. The last bullet on screen are the e-learning initiatives. And Brandon was mentioning earlier about how important it is, the outreach and education. And while CLA might have now assumed much of the substantive law training, the state bar has not abandoned the area of training other significant areas such as legal ethics, elimination of bias, competency. And rather than the old school mode of holding classes in a conference room somewhere, the state bar is focusing on distance learning through e-learning. And the first thing out the gate was the 10-hour new attorney training program. Something in the pipeline is a training program for probationers. But the 10-hour new attorney training program, if you go to the next screen, requires every new attorney to take 9 courses that amount to a total of 10 hours in multiple topics, including multiple legal ethics topics, law practice management, elimination of bias, and competency, and they're required to complete this within their first year of being admitted. As of May 4th, over 10,000 attorneys have been enrolled in the system. Basically, if they go to their My State Bar profile, if they're required to comply with the new attorney training program, there is a prominent notice there on how they can get to the e-learning program and start completing that training. About half of them, of that 10,000, have in fact completed the training. The other half have not, and of those who have not, 4,000 haven't reached their 1-year deadline. So they still have time to complete it. And in fact, the e-learning program, one of the reasons why I think the State Bar is moving this direction is that it's very user-friendly. You don't have to sit down and do all 10 hours at once. You can start it, stop it, and come back and resume where you left off until you've completed it. The last bullet on the screen, though, does indicate that 900 attorneys, over 900 attorneys, have not completed training, and they are past their one-year deadline. Now, what that means is that this will go into the normal cycle of notice and enforcement as any other MCLE issue. And the potential here is that if they don't ultimately complete the requirement, that they may be enrolled administratively inactive, which would mean they're not entitled to practice law. But hopefully they'll get around to completing that. The probation training e-learning project that's in the pipeline, it will augment what commonly happens in probation, which is that a lawyer is ordered to, quote unquote, read the rules of professional conduct. So instead of just reading the rules, it's anticipated in the future, those same probationers will be ordered to take an e-learning course and actually pass the test at the end of the course by a certain grade in order to demonstrate their knowledge of the rules of professional conduct. And I don't want to take up all the time. I want to leave ample time for questions. Many of the specialists in my office in their areas are also on the line. So we're happy to answer any question you have about professional competence.
Thank you, Randy. So one of the state bar-wide things that we've tried to do in this board year is to have different portions of the bar give presentations to the board members. Hopefully it's instructive to those who have just joined the board. So this is a chance to ask Randy any of the nitty-gritty questions. So does anybody have any questions for Randy?
I have a quick one.
Okay, Chris.
Mr. Chair. Yeah, I was just, this is great. This is really good information, Randy. I'm wondering, like, where does this work align, or would you say fit within the strategic plan? I was looking at a couple of different goals, and it seemed like it could go in a couple of different places, but I just wasn't sure of, like, where you think this sits. And then the word ethics hotline, like the ethics word is nowhere in the strategic plan. I haven't seen it. I just wasn't, it seems like it's a nice alignment in there somewhere. But I'm just curious about where we think that, where does this align?
Well, I don't believe there is a specific ethics hotline provision of the strategic plan.
Right.
And I think the use of ethics, one of my mentors, Bob Hawley, used to not like it when I referred to it as ethics or legal ethics. He always thought professional responsibility was more descriptive. And when you think about it in terms of professional responsibility, then it does, I think, fit at least one of the places in the strategic plan with the discipline system. Because if you didn't have, as the Supreme Court observed, things like the ethics hotline, then you would be potentially having more persons entering the discipline system. If you didn't have something like mandatory fee arbitration, then anytime there was a fee dispute, that might end up in the discipline system. So I hesitate to call it necessarily preventative, because many of the discipline violations in the discipline system are intentional conduct. And if someone's going to steal from the trust account, no amount of ethics hotline is to keep them from stealing from the trust account, if that's, the path they're on. But it is something that supports the discipline system by keeping other people's out of the system.
And I would note,
you.
as a follow-up to that, the State Bar's mission statement actually includes very clearly that part of protecting the public includes the advancement of the ethical and competent practice of law. And that is a big part of what the Office of Professional Competence is designed to do, is to work to advance the ethical and competent practice of law.
Yep, see that. Okay, no, this is really helpful. Thank you. Thanks.
And Chris, I think you bring up a great point. In goal 2, and if you go to the strategic plan, that's page 3, it goes through some of the things that we are on track to achieve, one of which is a self-assessment model, which other states have implemented and we're looking at implementing as well. And then by July 2021, creating a fully articulated preventative education approach to include that self-assessment component, and then other components where we've seen other individuals fall astray. So hopefully have those preventative measures in place.
Okay. Yep, I see that. Okay, thanks. It's very helpful. Thanks.
All right, any other questions? I know Randy does a great job presenting, so don't feel intimidated by him. Going once, going twice. All right, Randy, thank you so much for your work in this office. And to the employee that you mentioned, thank you for your, if he's listening, he or she's listening, then thank you so much for your dedication to the State Bar. You're going to be missed, and we look forward to other State Bar employees filling that void and providing the excellence that people here in California have come to expect from the State Bar. So thank you for your service.
Thank you, Brandon.
All right, and we have nothing further on the open agenda. We are now going to be going into closed session, and that is going to be pursuant to Government Code Section 11126 sub C sub 2. Committee members, please check your email. You should have received a invite for that closed session. Once we complete the closed session item, we'll come back into open session and adjourn the meeting. So thank you to everyone who listened. I hope you enjoyed the presentations today, and we'll see you on the other side.
Thank you, Brandon.
Thanks, Brandon.
Thank you, Dag.
Take care. How's your little girl?
She's great. Yeah, I was going to try and have her make an appearance, but she was sleeping.